your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. I'm your host, Daniel, and I want to say one thing. To all the new subscribers to this channel, thank you very much for your support. And I do appreciate every single one of you. Today is Judge Aaron Gauthier, Gauthier's courtroom. This ought to be interesting. Let me get this full screen, and we will go.
25th, you violated state law by engaging in elder abuse against Victoria Dock Stater in the matter of the 53rd Circuit.
Okay, hold on.
All right, good afternoon. Are we on the record there in Presqu'île?
We can hear you, Your Honor.
Are we on the record then?
You're on the record.
All right, good afternoon. We are on the record in the 53rd Circuit Court for the County of Presqu'île. We are providing public access both in the courtroom in Presqu'île County and also online. I am appearing from the circuit courtroom in Sheboygan County by video conferencing. We are here for a probation violation arraignment in the matter of People of the State of Michigan versus Alicia Marie Dockstader. It's file 24-93008FH. Counsel, you want to state your appearances beginning with People?
Good afternoon, Your Honor. Zachary McLennan on behalf of the people.
Your Honor, Mike Vogler, representing Alicia Docksetter for this arraignment.
All right, and so we have Ms. Dockstader and her counsel appearing together from the Presque Isle County Jail. Mr. McClellan, the prosecutor, is present in the courtroom in Presque Isle County, and Agent Lesky is appearing by Zoom video. She's the supervising agent. Ms. Dockstader, it's alleged that you're in violation of your probation in 6 respects. Some of them overlap a bit. Count 1 alleges that as of August 26th, 2025, you have failed to comply with substance abuse treatment. Count 2 alleges that you have, on or about August 25th, 2025, engaged in abusive behavior toward a Victoria Dockstader. Count 3 alleges that as of August 25th, 2025, you have failed to enroll in any educational programming. Those are technical violations. The maximum penalty would be 15 days for the first, 30 days for the second, 45 days for 3 of them. Count 4 alleges that on or about August 25th, you violated state law by engaging in domestic violence against Victoria Dockstader. Count 5 alleges that on or about the same date, August 25th, you violated state law by engaging in elder abuse against Victoria Dockstader. And count 6 alleges that on or about the same date, you violated state law by interfering with electronic communications. Those are not technical violations. That means that if you are found to be guilty for any of those or admit to it, I could revoke your probation and sentence you on the underlying offense. And you are on probation for the offense of domestic violence 3rd, which is a 5-year maximum felony. Do you understand the maximum penalty, Ms. Dockstader?
Yes, Your Honor.
And you have
Yes.
the right to have a hearing. You have the right to have a hearing on these allegations where they would need to be proven by a preponderance of the evidence. You have the right to the assistance of a lawyer at any such hearing. And if you request and qualify, the appointment of an attorney at public expense. You can present witnesses in your own defense and evidence in your own defense, and you can question any of the witnesses presented against you. Do you understand that the rights that you have to a probation violation hearing?
Yes, Your Honor.
Mr. Vogler, do you know how she wishes to proceed?
Your Honor, at this time, I would ask the court to set the matter for a probation violation hearing. She has made a request for appointment of attorney. I have the form filled out. I'll give it to the clerk here in Rogers City to get up to you.
And do you know to whom it'll be appointed? You had her on the underlying case. Will you be
Yes,
representing?
I'll be the person, yes.
Okay. All right, I'll enter a plea of not guilty for Ms. Dockstader and review the form when sent up. And I presume I'll approve that for referral to the Indigent Defense Authority in Presque Isle County for appointment of Mr. Vogler. We can schedule it for a probation violation hearing on September 8th at 9:20 a.m.
Okay.
And is there any request from the defense for any pre-hearing release?
Yes, Your Honor, I would ask the court in this matter to set a very minimal bond of $1,000, 10%. She is going to be arraigned at 2 o'clock this afternoon here in the 89th District Court on three felony charges and a misdemeanor charge. So my thinking is that if she's able to post a bond in that case, which I think is going to be much more than minimum, that would cover the situation here. If she is released, Your Honor, obviously she will not be going back to the place she was living. She'd be living with a Brandy Middaw in Onaway, who is her friend. And she is employed at this time, works for Final Touch Cleaning out of Alanson, Michigan.
Thank you, Mr. Vogler. Mr. McClellan, people's position?
Your Honor, the people would oppose any pretrial release at this time. She is on felony probation for domestic violence, third offense, and she's alleged to have again committed a domestic violence while on that probation, in addition to other felony counts. Given those circumstances, we would oppose release at this time, Your Honor.
All right, thank you. Well, in reviewing this file, looks like Ms. Dockstader's on probation for felony domestic violence that was committed when she was out of the jail from a previous domestic violence less than a month. And then while she's on probation for that, she's alleged to have engaged in more violent and assaultive behavior and facing more felony charges. Ms. Dockstader is not legally entitled to any release. What she is entitled to is a hearing within 14 days on a preponderance where the rules of evidence don't apply. And I'm going to give that to her, and that's scheduled for September 8th at 9:20 a.m. But I am not going to allow Ms. Dockstader to be released. She'll be held without release in the care and custody of the Presque Isle County Sheriff until further order of the court. All right, thank you all.
All right, thank you, Your Honor.
Mr. Rabson, have you had a chance over lunch break to talk with your lawyer about whether to testify or not?
Yes, I have.
Okay, you remember I went over with you your constitutional rights to testify or not testify?
Yes,
And he gives you some advice, but it's your choice.
yes,
Okay, if you choose not to testify, I'll tell the jury they can't use your silence against you, but you also do have the right to testify. You understand all those rights?
yes,
Do you have any questions for me or for your lawyer about any of those rights?
no,
And have you had a chance to make a decision?
yes, I have.
And what is your decision, sir?
I'd like to testify.
Okay. All right. And Mr. Gilbert, that's consistent with your conversations with them?
It is just conversations prior to the trial beginning and also at lunch.
Okay. So what we'll plan to do then is bring the jury out. Are you intending any rebuttal witnesses?
No.
Okay. So what I'll do is, if something changes, then you're going to have to interject to approach or stop me. But what I'll do, otherwise, we'll bring the jury out. I'll say Mr. Gilbert, and then you can say you're calling your client to the stand. We'll take his testimony. If you rest, we'll go directly into closing arguments and instructions.
Thank you.
Okay, ready for the jury then?
We are. All right.
All right, please be seated. All right, it's always nice to see the same number of jurors return after lunch, so thank you, so that we didn't have to send out anybody searching after you. Mr. Gilbert?
Yes, I'd like to just call one witness, Your Honor. I'd like to call William Rapson.
Okay. Mr. Rapson, you want to come on to the witness stand, please? Raise your right hand for me, Mr. Rapson. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can have a seat.
Can you hear me okay?
Yes,
Okay. Sir, can you state your name for the record, please? Can you state your name for me, please?
William Arthur Rapson,
Okay. And where do you currently reside?
North Country Motel.
Okay. All right. And do you know why you're here today, Mr. Rapson?
Yes,
Okay. And there was an incident back in August of 30th of 2024. Do you remember that?
yes.
And can you tell us what happened that day?
I was driving down the road and these two dogs come running out of the little wooded area there towards the truck. I swerved to miss them, but I bumped one of them with my bumper.
Okay. Did you see what happened to the dog after you hit the dog?
The dog got up and then the owner showed up. So he ran to his owner.
Okay. And so did you intentionally try to hit that dog that day?
No,
Okay. And what were you doing at the far end of that road, the dead end road that you live on?
I got or had a bait pile in my backyard and I heard a gunshot.
Okay.
That's what made me go down there.
Okay. Well, you heard audio today. Why did you tell the deputies that you weren't driving that day?
I don't know.
Okay. Do you remember telling the deputies that?
No, I don't.
Okay. But do you remember the deputies looking over your vehicle?
Yes,
Okay. In your garage?
yes.
Okay. Now, do you get along with the dog's owner?
I thought we got along, yes.
Okay. Also, we heard testimony today about poisoned meat by your house.
That I don't know anything about any meat
When was the first time you heard about this poisoned meat?
today.
Okay. And again, you're telling this jury that you did not intentionally hit that dog,
Not intentionally, no.
but you did hit the dog.
But I did hit him, yes.
Okay. Now, do you dislike these dogs for any reason?
No,
Okay. And again, you don't remember why you told the officers that you weren't driving that day?
no, I don't.
I have no further questions. Thank you, sir.
Any cross-exam?
I speak softly sometimes, so let me know if you can't hear the question, okay?
Okay,
Okay. So after you hit Katie, what did you do next?
I continued on going home. The dog didn't appear to be, damaged, or, he wasn't waddling off with a limp or anything.
How did you know? Did you stop?
Because I stopped, yeah, when I hit him.
How long did you stop for?
Probably 10 minutes.
Did you talk to John McElroy when you stopped for 10 minutes?
Yes,
And did you talk to Gil Litzner when you stopped for 10 minutes?
no,
Did you exit your vehicle when you stopped for 10 minutes?
no.
No further question. Sorry, I have another question. Who did you tell about this version of events to? Did you tell anybody that you hit the dog?
No,
thank you. No further questions.
Any redirect? Just briefly.
Mr. Rabson, do you remember exactly how long you stopped for? Was it 10 minutes or was it less?
Between 5 and 10 minutes. It was a brief stop.
Okay.
I didn't check my watch, but it was real brief.
Okay. I have no further questions. Thank you, sir.
Any questions from the jury? You seeing none, Mr. Rabson, you can step back down to the table with Mr. Gilbert. Mr. Gilbert.
I have no further witnesses, Your Honor. I close. I rest.
Okay. Ms. Goodrich, closing argument?
Thank you, Your Honor. Good afternoon, and thank you for your service here today. We tried to be respectful of your time and made this trial move along as efficient as possible. You've heard the audio recordings, you've seen the photos and medical report, you've listened to the witness's testimony, and now it's your turn to deliver justice. We know what happened on August 30th of 2024. The defendant, angry with his neighbor, deliberately used his truck as a weapon against something his neighbor loved, his dog Katie. Let's walk through what we know. For years, William Rabson has shown hostility towards his neighbor, John McElroy. And what did the neighbor, Gil Litzner, tell you? He saw the defendant's vehicle deliberately swerve off the road and head straight towards the dog. He thought he was going to find the dog in a ditch. He saw the dog's mouth bleeding. John McElroy also headed that way, watched William Rabson's vehicle swerve towards his family companion, Katie, heard the contact, heard Katie yell, and saw the blood in Katie's mouth, then watched her limp. In reaction, he threw his pocket knife at Bill Rabson's vehicle. Then we have William Rabson trying to tell Sheriff Ross and Deputy Klatsky that he didn't leave his house. He didn't drive. Even after they told him, we have 2 witnesses that saw you. Here today, for the first time, he says that now he did hit the dog and that it was an accident. And he's never told anyone else except we're here today. He testified here today that he stopped his car for 10 minutes, but there was no version of events by John McElroy or Gil Litzner when they gathered together after the hit occurred. In fact, Gil Litzner testified, I yelled at William Rabson, trying to find out what was going on as he drove back down the road. We also had the windshield markings consistent with John McElroy's statements that he threw his pocket knife as a reaction to his dog getting hit. The evidence shows deliberate action by William Rabson, intent, malice, a man who was angry. We could hear it in his voice as he talked about John McElroy in the audio recordings. And he chose to take his anger not with words, not with finger gestures this time, but with a vehicle weighing thousands of pounds. William Rabson drove past his house to pursue Katie. Ladies and gentlemen, this was cruelty, this was calculated, this was criminal. We've watched as you paid attention to the testimony and evidence presented at this trial, and now we ask you to return a verdict based on the evidence and the testimony that the defendant is guilty of intentionally hitting his neighbor's dog, Katie, and driving recklessly. The contact could have killed, maimed, or disfigured Katie, but fortunately Katie survived the reckless actions and decisions of William Rabson that day. Thank you again for your service.
Thank you, Mr. Gilbert.
Just briefly. So good afternoon, everyone, and also we thank you for participating today. And this was a quick trial, and basically there's not a lot in dispute here. Most importantly, Katie is fine. There was no permanent injury. Even though that veterinarian was saying 4 days later she's completely functional. Everybody that witnessed this says she was fine after the incident. Our position is that this was not intentional. This was an accident. Thus would be not guilty of count 1 in this case. Even if you were to feel that this was intentional, does this act rise to the point in which you would kill, torture, mutilate, or maim this dog? And I would put before you, if that was the intent of my client, wouldn't he run right over the dog? That's not swerve at it, bump it, or that type thing. But again, my client is saying that he did hit the dog, but it was not by any means intentional. And then the last thing, like count two of this case, is whether or not my client was reckless when he did that. You would have to find that he was willfully and wantonly disregarding the safety of operating vehicle on that road. And on both of these counts, we'd ask you to come back with a verdict of not guilty. First, due to the fact that there wasn't any intent, and even if there was intent, it doesn't rise to a guilty version of this statute. And in addition, number two, that he did not willfully and wantonly disregard safety while operating on Stony Point Road. Thank you.
Ms. Goodrich, any rebuttal argument?
Again, I would just ask you as the jury to remember the testimony that you heard, the exhibits that you viewed, and the audio recordings that you heard, and find the defendant guilty. Thank you.
All right, thank you. Well, members of the jury, the evidence and arguments in this case are finished, and I'll now instruct you on the law. That is, I'll explain the law that applies to this case. Now, different from your blue notebooks, the final instructions I'm reading you right now, I will send you into the jury room with your deliberations with 2 written copies of them in black. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You mustn't let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions but ignore others. To sum up, it's your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. Remember, we said a person accused of a crime is presumed to be innocent. This means you must start with the presumption the defendant is innocent, and this presumption continues throughout trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements, and the prosecutor must prove every element beyond a reasonable doubt. The defendant is not required to prove his innocence or do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair and honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. So a reasonable doubt is just that, a doubt that's reasonable after a careful and considered examination of the facts and circumstances of the case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in the case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits and admitted into evidence, and anything else I tell you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he's charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They're only meant to help you understand the evidence in each side's legal theories. You should only accept the things the lawyers say that are supported by the evidence and by your own common sense and general knowledge. And the lawyer's questions to the witnesses are also not evidence. You should consider those questions only as they give meaning to the witness's answers. My comments, rulings, or questions and instructions are also not evidence. It's my duty to see the trial is conducted according to law and to tell you the law that applies to the case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express any personal opinion about the case. If you believe that I do have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts. You should decide this case from the evidence. At times during the trial, I may have excluded evidence that was offered or stricken testimony that was heard. Don't consider those things in deciding the case. Make your decision only on the evidence I let in and nothing else. And your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you shouldn't use any personal knowledge you may have about a person, place, or event. To repeat once more, you must decide the case based only on the evidence admitted during trial. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it's raining. Facts can also be proven by indirect or circumstantial evidence. And that is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial or indirect evidence. Circumstantial evidence by itself or in combination with direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You don't have to accept or reject everything a witness said. You're free to believe all, none, or any part of anyone's testimony. And in deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on any of the protected categories we described earlier. Again, take the time you need to test what might be an automatic or instinctive judgment and reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but I'll remind you of the questions that might be helpful to ask yourselves. Was the witness able to see and hear clearly? How long were they watching or listening? Was anything else going on that might have distracted? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did they seem to be making an honest effort to tell the truth? Or did they seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge their testimony? Do they have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect their testimony? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does their testimony seem when you think about all the other evidence in the case? Now, sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think first about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently. And witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with all the other evidence in the case. However, you may end up concluding that a witness deliberately lied about something that's important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You shouldn't decide this case based on which side presented more evidence or more witnesses. However, you should think about each witness and each piece of evidence and whether you believe. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard testimony from witnesses who are police officers, That testimony is to be judged by the same standards you use to judge the testimony of any other witness. You heard that a lawyer or lawyer's representative talked to one of the witnesses. There's nothing wrong with this. A lawyer or lawyer's representative may talk to a witness to find out what they know about the case or what the witness's testimony will be. So again, in count one, which is third-degree killing or torturing an animal, the defendant is charged in count one with the crime of third-degree killing or torturing an animal. To prove this charge, the prosecutor must prove the following element beyond a reasonable doubt: that the defendant committed a reckless act that the defendant knew or had reason to know would cause an animal to be killed, tortured, mutilated, maimed, or disfigured. Reckless act is defined as willful and wanton disregard for the safety of persons or property, or knowingly disregarding the possible risks to the safety of people or property. And animals are legally defined as property. Count two, reckless driving. The defendant's charged in count two with the crime of reckless driving. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant drove a motor vehicle on a highway or other place open to the public or generally accessible to motor vehicles. Second, that the defendant drove the motor vehicle in willful or wanton disregard for the safety of persons or property. Willful or wanton disregard means more than simple carelessness, but does not require proof of an intent to cause harm. It means knowingly disregarding the possible risks to the safety of people or property. And again, animals are legally defined as property. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about August 30th, 2024, within Sheboygan County. Any possible penalty should not influence your decision. If you find the defendant guilty, it would be the duty of the judge to fix the penalty within the limits provided by law. When you go to the jury room, you will be provided with written copies of the final instructions in the black notebooks. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to reach a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you'll discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. Therefore, it's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and don't hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you, or just for the sake of reaching a verdict. In the end, your vote is your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations or during, you may submit them in writing to the bailiff. If you want to communicate with me at all while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It's not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. So if you have any questions, knock on the door and the foreperson hands the question written down to the bailiff. When you reach a verdict, knock on the door and either give the bailiff a note that you've reached a verdict, or just tell the bailiff at that point you've reached a verdict. But do not tell the bailiff what the verdict is, and do not hand them the verdict form. We'll assemble everybody and bring you back in, and the foreperson should bring the verdict form with you into the courtroom, folded in half. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the exhibits that have been admitted, just send a note out asking for them. And when you go to the jury room, you will be given a written copy of the instructions you've just heard. As you discuss the case, you should think about my instructions together as the law you are to follow. The defendant is charged with 2 counts. That's the crime of third-degree killing or torturing an animal and reckless driving. These are separate crimes, and the prosecutor is charging that the defendant committed both of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all, any one, or both of these crimes, or not guilty. And I'll send you back also with 1 copy of the verdict form. It has the case caption. It says verdict form, you may return only 1 verdict on each count. Mark only 1 box for each count. And then there's count 1 with a box for not guilty and a box for guilty. Count 2, the same. So once you reach a unanimous verdict, you would check the appropriate box, and the foreperson would sign and date the form, fold it once in half, knock on the door, and tell the bailiff that you've reached a verdict. All right, now thankfully, nothing happened in the lives of any of the 13 of you here today. At this point, as I described earlier, we're going to select one of you to be excused as an alternate. If that's you, sometimes the alternate is relieved that they don't have to deliberate. Other times they are disappointed that they don't have to deliberate. Whichever the case is, I want to assure you that your presence is vital to provide the constitutional right to a jury trial. And we many times do have to rely on the use of an alternate. If you are excused, then you'll be welcome to either stick around in the gallery if you wish, or you can go home, whatever you want to do, and you'd be free to talk with anyone about the case, with the exception of any of the jurors who are still sworn as a jury, of course. All right, so at this point, I'll have the clerk randomly select our alternate.
Juror 47, Deborah Marie Fuller.
Right, and that is in seat 10. Ms. Fuller, thank you for your service. Do you have anything in the jury room?
No, I do not.
Okay, so you can exit right out that door. And
I'm gonna sit locked.
okay.
Over. You look like you were gonna go.
All right. All right, so if you want to go, you can slide right out the door right behind you.
Oh, I'm gonna sit right here.
I know, but can you go right out the door right behind you?
Oh, okay,
And then enter through the gallery doors?
okay.
Okay. All right, and then at this point, I will have the clerk swear the bailiff.
You do solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors in this trial from separating from each other, that you will not suffer any communication to be made to them orally or otherwise, that you will not communicate with them except on order of this court, and that you will not, before they render their verdict, communicate to any person the state of their deliberation or the verdict they have agreed upon.
All right, so at this point, the bailiff is going to show you back into the jury room, and he's going to give you the 2 black binders and the 1 verdict form.
All rise.
All right, please be seated. Obviously, I did not read, and I removed from the notebook the instruction 3.3 for defendant not testifying. Ms. Goodrich, are the people satisfied with the instructions as given?
Yes, Your Honor.
Mr. Gilbert, the defense?
Thank you.
If the jury sends out a note requesting an exhibit that by its note is just one of the photographs, do you want me to just send it back without convening counsel to consult about it?
No objection to
That'd
that.
be fine.
Okay, if they ask for one of the recordings, we'll come back and talk about how we're going to do that. All right, any other issues to put on the record from the people,
No, Your Honor.
from the defense?
No, Your Honor.
Okay, so as this court's practice, make sure we've got a cell phone where we can reach counsel if the jury does have a question or reaches a verdict, so we can reassemble without delay. And Mr. Rapson, I'm going to instruct you, we had a little miscommunication as well about about what happened over lunch and had to track you down again. So, Mr. Rapson, I'm going to tell you, you're going to be in one of two places only. In this courtroom or right next to Mr. Gilbert. Okay? That's it. You are with Mr. Gilbert or you're in this courtroom. Do you have any questions for me about that?
No.
Okay, you're not to go anywhere else because we need to reassemble quickly if the jury has a question or a verdict. If we're trying to reassemble and I see Mr. Gilbert and you're not with him and you're not in the courtroom, you will go to jail. Do you understand that?
Yes.
Okay. All right, we'll be in recess.
All rise.
To receive the verdict, counsel?
Yes, Your Honor.
Yes, Your Honor.
Okay, we have the jury. All right, members of the jury, have you selected a foreperson to speak for you? All right, so without telling me what it is, have you reached a verdict?
Yes.
Okay, would you please hand the verdict form to the bailiff? All right, Madam Foreperson, would you please stand and announce your verdict into the record?
Yes. On count 1, third-degree killing or torturing of an animal, we find the defendant guilty. Count 2, reckless driving, we find the defendant guilty.
Okay, and could you hand the verdict form back to the bailiff, please? Mr. Gilbert, would the defense like the jury polled?
No, thank you.
Okay. All right, well, members of the jury, thank you for your service today. You're excused in this matter and will be free to speak with anybody that you wish about the case. At this point, I'm going to have the bailiff show you back into the jury room, and I have to take care of something very quickly on the record. And then I'll be, I ask you to just wait around a minute or two, and I'll be back momentarily to speak with you.
All rise.
All right, please be seated. All right, defendant having been found guilty for the matter, Ms. Goodrich, do you have any motion?
Your Honor, I would ask that bond be revoked at this time since he's no longer presumed innocent. And after hearing the testimony today.
Mr. Gilbert, your response?
Obviously, we'd be opposed to that, Your Honor. Other than this morning, my client has never failed to appear for court, and we'd ask that bond stay as it is.
There was a bit of an issue with this morning with what Mr. Rapson's address was. Do we have a good address for him at this time?
I believe he's at the North Country Hotel.
Okay. And Mr. Rapson, if you change your address at all, you have to let the court know that day. You understand?
Okay.
We were here for a jury trial this morning and you weren't. We had to send a deputy out to get you. So it's very tempting to cancel your bond right now. So you sit in jail between now and your sentencing. So I know you'll be here for the sentencing. But he did have car problems that he's explained, and that was consistent with what the deputy reported to court staff when he came back. Mr. Rapson, other than the issue with his car today and has appeared for all court proceedings. I don't know how it's going to score out. I know there is a habitual notice, but I don't know how it's going to score out or what the sentence would be. And so I don't want to prejudge that. So I'm going to continue Mr. Rapson's bond. We'll schedule it for sentencing on October 7th.
Oh, my birthday.
At 3:10 in the afternoon. Mr. Rapson, before you leave today, I want you to go across the hall to the probation department, tell them you were just found guilty and they need to prepare, and you need to schedule an interview so they can write a report for me about what the recommended sentence would be. You have to cooperate with that, okay? Do you have any questions about that? All right, anything further from the people?
Your Honor, can Mr. Rapson be instructed that his behavior between now and sentencing would be considered at sentencing, so there's no retaliation against the witnesses testifying that testified?
Oh, yeah, so is there already a no contact provision?
Yes.
Okay, so there's a no contact provision with you and, Mr. McElroy.
Right.
Don't do anything to upset that.
No.
Okay. If you do anything like that between now and the sentencing, the sentencing would be a very bad day for you. You understand me? On October 7th, I'm going to decide if you go to jail or not, but for how long. So don't give me reasons that I don't already have.
Okay.
Okay. Anything further from the defense?
No, Your Honor, thank you.
Okay, we'll be in recess.
All rise.
Wow.
All right, so good afternoon. We are back on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And then we'll call our criminal docket. People v. Ralph Page. It's file 24-6875FH. Counsel, you want to state your appearances, please?
Anthony Julian on behalf of the people.
Thank you, Your Honor. Good afternoon, Brian, on behalf of Ralph Page.
All right, and we're here for a docket call and also a continuing status conference on a bond violation matter. What's our status, Mr. King?
Thank you, Your Honor. Mr. Juliet and I had a conversation today. We've asked for some discovery from their office with regards to some receipts for bills. We've had some estimates, but not any receipts. Mr. Juliet would have not known about our request until today, so I didn't expect you to have them today. But we can continue that. I would suggest maybe September 30th, since I'm not going to be here. It's a good day. So we should be able to have that all sorted by then.
Okay, any objection, Mr. Juliet?
No, Your Honor.
So we'll schedule it for a continued docket call and a status conference on the pending violation at the same time for September 30th at 1:40 in the afternoon. And Mr. Clean, if you or your client want that to be a contested evidentiary hearing on that violation, please let Mr. Juliet know.
Good luck.
Okay, you're all set today, Mr. Page.
You're all set. Well,
All right, let's call People v. Mid-Yet.
oh,
Well, this is file 25-7037FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
Good afternoon, Your Honor. Michael Hackett on behalf of Joyce Midyat.
Good afternoon, and we're here for a docket call and also Status conference on several pending violations. Mr. Hackett, do you know what the status on the case is or how Ms. Midget wishes to proceed?
Your Honor, we were assuming that we would proceed with the taking of a plea today.
Okay. And is there a plea agreement you can give the bailiff? All right, Ms. Midget, would you please stand and as best you can, raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can be seated if you wish, Ms. Midget. That's fine. All right, Ms. Midget, the guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen carefully. If you have a question, ask me. If you need a minute to talk to Mr. Hackett, you just let me know. I have to tell you the maximum penalty for the charge that you're offering to plead to. Possession of cocaine, count 2, carries a maximum penalty of 4 years in prison and or a $25,000 fine. Do you understand that maximum penalty?
Yes, sir.
Are you on probation or parole anywhere?
Here.
For another case? Oh, you're on, okay. Did you have any other cases pending at the time of this matter?
Not currently.
Okay. All right, if you plead guilty, you won't have a trial and you'll be giving up all the rights you would have at that trial. Do you understand that?
Yes, sir.
I want to remind you of the more important of those rights. You'd have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proves your guilt beyond a reasonable doubt. The right to have the witnesses against you appear and to question them. The right to present witnesses in your own defense and have me order them to show up. The right to testify in your own defense or to remain silent and not have your silence used against you. Do you understand all those rights?
Yes, sir.
Do you have any questions for me or Mr. Hackett about any of those rights?
No, sir.
Do you wish to give up those rights and enter a plea today?
Yes, sir.
If I accept your plea, you can't come back later and tell me that somebody threatened you to make you enter it or pressured you or that you were promised things beyond the plea agreement. You waive any such claims by entering your plea. Do you understand that?
Yes, sir.
Also, when you enter a plea, you lose the right to appeal. And if you want to appeal, you have to seek permission by filing an application. The types of issues you could raise on an appeal after you plead guilty are very limited, much more limited than if you were convicted after a trial. Do you understand this?
Yes, sir.
The plea agreement provides in exchange for your plea to the possession of cocaine, the prosecution will dismiss the remaining counts, and there's a sentence agreement for 7411 probation, which means that you would the file would be non-public, and then if you successfully complete it, the charge would be dismissed. You wouldn't have a public record of the conviction. Do you understand that?
Yes, sir.
Mr. Hack, is that a full, fair, and accurate statement of the terms of the agreement?
Yes, Your Honor.
Ms. Goodrich?
Yes.
Ms. Midget, that sentence agreement for 7411 is not binding on me. If I didn't want to follow it, I wouldn't have to. But if I didn't follow it, you would be allowed to withdraw your plea. Do you understand that?
Yes, sir.
There's an important exception to that. If you engage in misconduct between now and the sentencing, say by absconding on a bond or failing to appear, violating bond conditions, or committing more crimes, then by your misconduct, you would lose the right to withdraw the plea, even if I didn't follow that sentence agreement. Do you understand that?
Yes, sir.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, sir.
Has anybody threatened you to make you do so?
No, sir.
Is it your own free choice to do that?
Yes, sir.
Knowing all this, how do you wish to plead to the charge in count 2, possession of cocaine?
Guilty.
Back on May 9th of this year, were you in Sheboygan County?
Yes, sir.
And within Sheboygan County, were you in possession of the controlled substance cocaine?
Yes, sir.
Did you know that you were in possession of a controlled substance?
Yeah.
Okay. And it turned out that that tested for cocaine?
Yes, I found out.
Okay. Do you have any reason to challenge or doubt that chemical test of the substance?
No, sir.
And do you have any lawful authority to possess that substance?
No, sir.
Mr. Hackett, you satisfied with the factual basis?
Yes, Your Honor.
Ms. Goodrich?
Yes.
Mr. Hackett, are you aware of any other promises, structure, inducements?
No, Your Honor.
Ms. Goodrich?
There you are.
Mr. Hackett, in your judgment, have I fully complied with the requirements of MCR 6.302?
Yes, Your Honor.
Ms. Goodrich?
Yes.
All right, Ms. Midyat, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So I'll accept your plea. We could schedule sentencing for Tuesday, October 7. Afternoon or morning work better for you, Mr. Hack?
Morning.
Okay, we could schedule this for 9:50 a.m., 10 to 10. Ms. Midyat, you'll have to cooperate with the scheduling and participating with an interview with the probation department so they can write a report with recommendations. And counsel, what are we doing with the pending bond violation issues?
Your Honor, I would not object to adjourning those to sentencing and having Ms. Midyat released today and see how she does between now and sentencing.
That's our request. Okay, so we can continue. Continue the contempt matters to the sentencing date. And we want bond reinstated on the same terms then, Ms. Goodrich?
Yes, Your Honor, thank you.
All right, Ms. Midyat, we're going to reinstate your bond with the same conditions. I want you to understand, I want to reiterate some of the things I said to you. So now, between now and the sentencing, if you stay out of trouble, there's no reason for me not to give you that 7411 at the sentence and probably not give you any more jail. You seem to have a lot of problems on bond. If you have problems between now and the sentencing on bond, you might not get the 7411 and you're very likely to receive jail then. So I don't know, and you're not admitting anything today about the bond. I'm not asking you to. I'm just telling you, I don't know what the issues were. But you want to talk with Mr. Hackett and solve whatever those problems were so that they don't happen anymore.
Yes, sir.
All right. Okay. So we'll reinstate bond, same conditions. It's your responsibility to contact the probation department to schedule an interview. So you want to do that right away when you're released.
Yes, sir.
And we'll see you on October 7 at 10 to 10 in the morning. Anything further, Mr. Hackett?
No, Your Honor, thank you.
Anything further, Ms. Goodrich?
No, Your Honor, thank you.
Okay. Okay, Boom, so I think this might be Miss. Is Miss Strack present in the courtroom or is she zooming in? She must be zooming in.
Okay.
Hi, are you Miss Strack?
Yes.
Okay. All right, good afternoon, Miss Cahoga-Boom.
Good afternoon, Judge.
All right, so we're here in People v. Alexia Strack, file 25-7021 for docket call. We've got Melissa Goodrich for the people, Diane Cahoga-Boom for the defense zooming in. Ms. Strack is zooming in as well from a separate location. So please let me know if you need a breakout room at any time. And we had continued this for, it was scheduled for a plea taking, and I had some extensive discussions with counsel in chambers with questions I had about the case. So what's your intention at this point, Ms. Cahoga-Boom, to go forward with that plea?
It is, Your Honor.
Ms. Goodrich, is that correct?
Yes.
I did note as I was reviewing it further that it was a no contest to an added count 5 CSC 4. That's fine as a charge bargain. There is a sentence agreement for no immediate jail. but then also with substance abuse and mental health assessments and following recommendations as part of probationary terms. I guess I want to advise all parties that on my review of the facts in the affidavit and considering the facts and circumstances of the case, I am not likely to follow that sentence agreement. I'm likely to impose a sentence of fines and costs only. So if it is particularly important for the, and in fact, I mean, I don't see any reason why I couldn't just do that today and proceed to immediate sentencing if parties waive the preparation of a pre-sentence report. It would not be my intention to place Ms. Strack on any probationary term. So I don't know if that changes your analysis, Ms. Goodrich, and whether you'd like to go forward with this plea today or not.
Oh, Your Honor, I would ask for sentencing to be set so I can explore some additional information that I received, but I have no objection to the court crossing out the sentence agreement if.
Well, I can just leave it there,
Okay.
but then if I just want to let you know, if I at sentencing am not going to follow it, you could withdraw your plea.
Sure.
Okay, so Ms. Hogaboom, the prosecutor would like me to take the plea, set it for sentencing, get a PSI, and then if I end up not following the sentence agreement at sentencing downward, the prosecutor can at that point decide if they want to withdraw from it. Does that sound fine?
And that sounds fine, Your Honor. The defense is, we would be fine proceeding today, but we understand the prosecutor has their right to require us to go through the procedures.
Okay, very good. All right, so Ms. Strack, would you please raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you can put your hand down. I'm not going to ask you about what happened because it's a no contest plea, but I'm going to ask you a lot of things to make sure you understand your rights. So the reason for a no contest plea, Ms. Goodrich, would be, or I'm sorry, Ms. Hogaboom would be.
Intoxication, Your Honor.
Okay. And Ms. Goodrich, you consent to that?
Yes.
All right. So Ms. Strack, do you understand that a no contest plea does have the same legal effect in the criminal case as a guilty plea, meaning that you would stand convicted of the offense and I would have the jurisdiction or authority to sentence you?
Yes.
Okay. So, and Ms. Hogaboom, do you consent to the filing of the amended information?
I do, Your Honor.
All right, Ms. Strack, you'd be pleading no contest to added count 5. That is a charge of criminal sexual conduct in the 4th degree by relationship to the 3rd degree. It's a high court misdemeanor punishable by a maximum of 2 years and or $5,000, mandatory HIV and STD testing, and it is a tier 1 offense under SORA, unless you have prior convictions for SORA crimes, which would increase the level of SORA. Do you understand the maximum penalty you could face?
Yes. Yes, Your Honor.
All right. Did you read and understand the rights listed on the advice of rights form?
Yes.
Do you have any questions for me or for your lawyer about any of those rights?
No, Your Honor.
Do you wish to give up those rights and enter the no contest plea today?
I don't know. Yes, I guess.
Okay, well, I mean, your options are either to exercise those rights and have a jury trial, or to waive those rights and enter the no contest plea to the 4th degree as in the agreement. Do you know which you prefer to do?
Yes.
Okay. If I accept your plea, you can't come back later and tell me that somebody threatened you or pressured you to take it, or that you were promised something outside the plea agreement. Do you understand that?
Yes.
Also, when you enter a plea, you lose the right to appeal. If you want to appeal, you have to ask permission to appeal. And the types of issues you can appeal after a plea are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, Your Honor.
All right, the plea agreement says that in exchange for your no contest plea to the count 5, CSC 4th, the prosecutor will dismiss the remaining counts And there's a sentence agreement for no immediate jail and probation with substance abuse and mental health assessments and follow the recommendations. Do you understand that plea agreement?
Yes, Your Honor.
Now, I don't have to follow that sentence agreement, but if I don't, you could withdraw your plea. Do you understand that?
Yes, Your Honor.
That's unless you engage in some misconduct between now and the sentencing, in which case you lose the right to withdraw the plea. Do you understand that?
Yes, Your Honor.
All right, other than the plea agreement, has anybody promised you anything to get you to plead no contest?
No.
Has anybody threatened you to make you do so?
No.
Is it your own free choice to enter this plea today?
Yes.
Knowing all this, how do you wish to plead to the charge in count 5, CSC 4th degree, guilty, not guilty, or no contest?
What? No contest. Yes.
All right, Ms. Strack, it appears that you're speaking with somebody there in the space with you. Can you tell me who that person is?
It's just my boyfriend. I'm really nervous right now. I don't really
Okay.
know what to say.
Okay, that's fine. I just want to make sure that he's not influencing your decision in any way.
No, he's just helping me like with my head right now. Like,
Okay.
I'm just really
Okay, you want
nervous.
to plead? That's okay. You want to plead no contest to the CSC 4th degree then?
Yes.
I have reviewed an affidavit, a complaint and affidavit, which we'll have marked as joint exhibit in the file. I find that it does establish jurisdiction and venue and the elements of a sexual contact with somebody that the defendant was related to by blood or affinity to the 3rd degree. Ms. K. Hogaboom, do you agree that a factual basis has been established?
I do, Your Honor.
Are you aware of any other promises, threats, or inducements?
I'm aware of none.
And do you believe I've complied with MCR 6.302?
Yes, Your Honor.
Okay, Ms. Goodrich, do you believe there's a factual basis?
Yes.
Are you aware of any promises, threats, or inducements?
No, Your Honor.
And do you believe I've complied with the statute?
Yes.
All right, Ms. Strack, I find that your plea is knowingly, understandingly, and voluntarily made, and that there's good reason for me to believe that in fact and in law that you are guilty of that offense. So I'll accept your no contest plea to it. We could schedule sentencing, Ms. K. Hogaboom, for October 7th. And that would typically be in person. Are mornings or afternoons better, or given what I've indicated, or do you want to request a video sentencing, or what are your thoughts?
Your Honor, I do have, unfortunately, another sentencing which requires me to be in person on the morning of the 7th, where I'm not sure that I'm happy to come in person for the sentencing, but I would just ask if we could adjourn it out another week or two past that, so that it's not on the 7th. I just don't think that geography-wise, there's any way for me to make the 7th work and be there in person. But I am happy to appear in person to assist Mr. at our sentencing.
How about October 21?
I am wide open that day, Your Honor.
Okay, morning or afternoon work better for you?
Let's do afternoon.
All right, let's schedule this then for 1 p.m. All right, so Ms. Strack, your sentencing is going to be scheduled on October 21 at 1 in the afternoon. You have to be here in person on that day with your lawyer, and you have to contact the probation department here in Sheboygan and schedule an interview so they can write a report for me. And Ms. K. Hogaboom can help you with getting that phone number if you need and helping you arrange that. But it's your responsibility to make sure that happens, okay?
Okay.
Do you have any questions for me or for your lawyer at this time?
No, Your Honor.
Anything further from the people?
No, Your Honor. Thank you.
Anything further from the defense?
Nothing. Thank you, Judge.
Okay, thank you. Have a great day.
You too.
All right, and that'll bring us to People v. Kiefer. Mr. Klein. All right, we've got People v. Jacob Kiefer, file 24-6934FH. Counsel, you want to state your appearances, please?
Anthony Julian on behalf of people.
Brian, we have a Jacob Key.
All right, we're here for sentencing, an attempt B&E motor vehicle, and attempt larceny over 1,000. Mr. Clayton, have you had a chance to review the pre-sentence report and recommendations?
I have.
Any additions, corrections?
No.
The advisory guidelines are scored 0 to 17. Any scoring challenges?
No.
I
No.
did have an opportunity to review several letters of support for your client. I'll make sure that you and he know that. And Mr. Juliet, any additions, corrections, or scoring challenges from the people?
Just one correction that goes to the sentencing credit. It does have 272 days as of today's date. That's on page 2 of the basic information report and page 2 of the pre-sentence investigation report.
Okay, 272 days?
Correct.
Okay. All right, Mr. Clayton, does that agree with your math?
Yeah, that's correct.
All right, anything you'd like to say on behalf of your client?
Yes, Your Honor. As I look through Mr. Kiefer's record, I would clearly indicate to the court that he's had a tough go of it with the drugs. There's no question. I know this is a drug case, but that's probably to his credit. The only thing I see that's of similar ilk in this case, it was a 2010 retail fraud in Jackson County. I don't see any theft crimes on his record. And I don't necessarily agree with the court or with the agents. I would say it's more just an opinion. The last sentence of the recommendation narrative. Starting with the jail only sanction has been recommended in this matter as community supervision was just completed. And then an emphasis added, and he clearly has no intention of investing in making positive life change. So I actually disagree with that, and I'll tell the court why. Throughout the course of this, obviously, it's been kind of a protracted case all the way up to literally the eve of jury trial when we came to this resolution. But in the course of it, I've had a lot of chances to talk to Mr. Keith. I think that that's not really true, that he has no intentions. I think he's got to struggle to, I don't think it's going to come to him organically. I mean, he and I have had conversations about criminal associations, hanging out with people who are not looking out for his best interest, cutting ties with people who are destructive in his life. He's answered the questions. He's told me what, I don't think he's told me what he thinks I want to hear. I'm trying to give him a roadmap to a better life. I think he's got a lot of positive qualities and characteristics. I think his biggest downfall is his ongoing drug addiction. And until he gets that handled, he's going to continue to have problems. I hope he doesn't. I find Jacob to be a pleasant person. When I talk to him, I think he's a hardworking guy. I think he's got some struggles. He has some struggles, even when this case was pending, he has some struggles in the jail. I wasn't involved in those cases, but I'm aware of them. But nonetheless, he's wasted a lot of his life, big portion of his life, especially in the last 2 decades, sitting in some sort of incarceration, whether it's a jail or a prison cell. He's got to strive to do better. And I think he's just got to recognize, honestly, in my opinion, that this isn't going to come organically to him. He's got a personality of such that addiction is in his nature, whether it's drugs or alcohol or gambling, I imagine, or any other vice. He's got to control it. But the only person at the end of the day who can keep Mr. Kiefer from using is Mr. Kiefer. If he's committed to a lifetime of sobriety from here on out, I hope he is. He said he is. He's told me he is. If he is, then he will certainly be a success. He has the ability. Conversely, if he goes back to that lifestyle, I'm saying this to the court, but I'm also saying it for Mr. Kiefer's benefit, as he's sitting right next to me. He goes back to that lifestyle. There's no reason to think it will be right back in front of you, or worse, death. Because that's where drug addiction leads us, to prison or to an early grave. I don't want either one for Mr. Kiefer. So I ask the court to sentence as recommended. It seems appropriate for the facts and circumstances and the guidelines scoring in this case. But I certainly hope that the court's heard my words and understands my position. I also hope that Mr. Kiefer understands that my desire, my strong hope for him is a better life. And it only comes through sobriety.
Thank you, Mr. Clay. Mr. Kiefer, you don't have to say anything today, but it is allowed. Is there anything you want to tell us or not?
Yes, Your Honor. I'd like to apologize to Mr. Tyler Nash and his family. It is never right to impose on the rights and property of another person or to disturb their way of life, peace of mind. I feel terrible for my actions. I did exactly that. So I'm sorry to Mr. Nash for the negative impact I've had on him and his family. I'd also like to apologize to my family, loved ones in the community. I've embarrassed them, burdened them, and let them down. I do want to do better. I strive to do better. I'll be the first to admit my actions were totally unacceptable. And I take full responsibility for my transgressions, ready to accept my sentence.
All right, thanks, sir. Mr. Goodrich, any recommendations from the people? Oh, sorry, Mr. Julian.
Just briefly, the recommendations for 1 year in jail. That seems appropriate given the guidelines range. Based on his prior record, I think there's also an argument that he should go to prison. But this is a property crime. And I guess I'll just say this, I'm encouraged to hear the apology, but being that it's just a property crime, obviously the grids go down, but they still have an impact on real people. You know, there's no psychological injury, but I don't think anybody wants their vehicle get broken into at night. So they do have an impact on people. Otherwise, I support the recommendation.
Okay, thank you. Mr. Kiefer, if you please stand for the court sentence. Well, Mr. Kiefer, you are 35 years old and you've already got 7 prior felonies. And I was struck, I didn't really know a lot of your criminal history because just before I took the bench, you got a pretty significant sentence from my predecessor. So I haven't really dealt with you much until now. I mean, I was in the prosecutor's office around the time of some of these, but I don't know that I was really involved in it. So I haven't had a lot of, you weren't really on my radar, just let me put it that way, which is a good thing, right? If the circuit judge knows who you are, it's not the best thing. But I didn't really know too much about your history. So I was struck by this, that in 2010, you got into drug court. And while you were in drug court, you had a new delivery charge and got kicked out and got some jail in 2012, a year in jail. 2013, more delivery charges. You plead in 2014, you're sent to prison for a couple years. You're paroled in 2016, discharged in April 2017. By July, you got more felonies. In 2018, you're sentenced on those. You're sent to prison for more than 5 years, 5.5 years. You're paroled in 2023. You're discharged in July of 2024. And then within a month, you catch this case. And your bond gets revoked in December, and you've been sitting in jail for about 9 months. So you're 35 years of age. Since you were like 20, you have been either in jail, in prison, or on paper. Are you getting tired of it yet? I mean, we talk about sometimes people doing life on the installment plan, and that's the path you've been on. You are catching a really big break today to not be doing your next installment in prison. To have 7 prior felonies If you were convicted as charged with the habituals, that would almost certainly be a prison sentence. And with it, with the resolution down to the attempts, the guidelines at 0 to 17, the recommendations for a year, and you've done almost all of that with good time with what you've been sitting. So you're going to soon get out, and you're not going to be on paper with me or anybody else. And I guess we're going to find out, like what Mr. Clayton said. We're going to find out if you're tired of this or not. You don't need to be on probation to go to treatment or go to AA meetings or NA meetings. So you should get yourself to those places. It sounds like you've got family that are supportive and want to help you. You're able to, describe your thoughts about this in a way that, makes me think you've got a lot more potential than what you've been living up to so far. And now you've got +2, so now you got like 9 felonies, and you are on the circuit judge's radar now. So you come back for another felony, I can promise you it's not going to be local jail. That'll be your next installment. So you're kind of at an important decision point in your life. The next felony case you get could be a long time. The last prison sentence you got was 5.5 years. It usually doesn't go down. Today it's going down, you're only getting a year. That doesn't happen much. You come in on more felonies, you're probably going, and it's for more than half a dozen years. So I hope you don't do that. Mr. Clayton hopes you don't do that. Nobody in this room hopes you do that. But we don't have any control over that. Only you do. In any event, I think given the guidelines and the information contained in the pre-sentence report, the recommendations are proportionate. So I'm going to assess a crime victims assessment of $130, crime or state cost of $136, court cost of $350. Upon your release, you'll have to set up a payment plan with the court to make reasonable efforts to get that paid down. And I'm going to order you serve 12 months in the Sheboygan County Jail with credit for 272 days previously served. That is within the advisory guidelines range. And given the felony record, there's reasonable grounds for incarceration. And you can file an appeal if you wish by filing an application with the Court of Appeals. If you want a lawyer, you have to ask me within 6 months. We're going to make sure you get some appeal paperwork about that and ask you to initial one for us and fill out the other one if you want to take an appeal. All right, good luck to you, Mr. Keith.
Thank you, Don.
Stop. Let's call People be Brandy Bedell.
Your Honor, on this case, we want to try to accomplish a couple things today. I have to do some paperwork with Ms. Bedell with regards to a written plea agreement, advice rights forms and things of that nature. So I want to try to accomplish that. So I have to get that from Ms. Goodrich. So if we could.
You want me to pass the case? You want to sit with her in the jury box and do that? Is that okay?
If Ms. Goodrich has it, I can certainly.
Well, let me see. Are we? And I can.
No, I can probably do it. No, it's all ready. We talked about it. So
let's go off the record for a minute.
Nine felonies? Jesus. Yeah, 78 subs. Yeah. But we can do better than that. We can do better than that. I think we could probably hit over 100 before the end of this year. But the main thing is I'm not promoting my channel on other channels. I don't make myself visible on other channels. Now, Spawn, that's a different story. I'll go on Spawn, I'll say hi, Spawn. I'll say hi to everybody in the chat. I know he just went live, so I don't know what he's talking about today. I know I listened to part of it this morning, from what he did this morning.
All right, so this is files 25-7038 and 7039. We've got Ms. Fidel present with the lawyer, Mr. Klain, prosecuting attorney, Ms. Goodrich. All right. And Ms. Goodrich, are you going to later file an amended information?
Yes,
The harboring misdemeanors, what's the maximum penalty on that?
I think that's 93 days.
Is there any fine with that, you know? Ms. Fidel, would you please stand and raise your right hand as best you can? Just swear to tell the truth, the whole truth, and nothing but the truth, so help you God. You can be seated. Ms. Fidel, a guilty plea hearing is an important event. It includes the waiver of constitutional and other rights that you have, so I want you to listen carefully. If you have a question, ask it. If you need more time with Mr. Klain, you just let us know, okay?
Your Honor, that is 93 days and or $500 fine.
Okay. All right, so Ms. Fidel, I have to advise you of the maximum penalty that you face for these charges. In file 7038, harboring misdemeanors is a misdemeanor punishable by a maximum of 93 days in jail and or a $500 fine. And in file 7039, count 2, possession of methamphetamine is a felony punishable by a maximum of 10 years and or a $15,000 fine. Do you understand the maximum penalty for both of those files?
Yeah.
Are you on probation or parole? Well, that meth really be messing up people, man. It's really sorry. It's really sad to see people messed up on meth or coke. It's just a sad thing.
And did you read and understand the rights listed on the advice of rights form? Do you have any questions for me or Mr. Klain about any of those rights? Do you understand that if you plead guilty, you give up those rights? Is that what you're choosing to do today?
Yes.
If I accept your plea, you give up any claim that it was caused by promises beyond the plea agreement or by any threats. Do you understand that? Also, when you enter a plea, you lose the right to appeal. And if you want to appeal, you have to seek permission by filing an application. The types of issues you could raise on an appeal after you plead are very limited, much more limited than if you were convicted after trial. Do you understand that? The plea agreement provides in exchange for plea to those charges, the prosecutor will dismiss the other charges. And in the felony file, there's a sentence agreement for 7411, which would be a non-public file for probation. And if you successfully complete that probation, it'd be dismissed with no public record of your conviction. Do you understand that agreement?
Yes, yeah.
Mr. Klain, is that a full, fair, and accurate statement of these terms?
It is.
Ms. Goodrich?
Yes.
Ms. Fidel, that sentence agreement for 7411 is not binding on me, meaning I don't have to follow it at sentencing, but if I didn't follow it, you would be allowed to withdraw your plea, not having gotten what you bargained for. Do you understand that?
Yes, sir.
There is an important exception to that. If you were to engage in any misconduct between now and your sentencing, say by not showing up for court, absconding on a bond, violating conditions of your bond, or committing new offenses. By that kind of misconduct, you'd be losing the right to withdraw the plea, even if I didn't go along with the sentence agreement. Do you understand that?
Yes, sir.
Other than the plea agreement, has anybody promised you anything to get you to plea?
No, sir.
Has anybody threatened you?
No, sir.
It's at your own free choice to do so.
Yes, sir.
Knowing all this, how do you wish to plead to the charge in count 7038, file 7038 to harboring misdemeanors?
Guilty, Your Honor.
How do you wish to plead to the charge in 7039 of possession of methamphetamine?
Guilty, Your Honor.
For the harboring misdemeanors, could you assist with the factual basis, Mr. Klain?
Yes, I just have to give them,
It was February 24.
I was more concerned about this thing. Okay. On February 24th of 2025, were you in Sheboygan County, Michigan, state of Michigan?
Yes.
City of Sheboygan?
Yes.
Did you have contact with an officer who was looking for a guy named Joseph Foley?
Yes.
And Joseph Foley had been at your house, correct?
Yes.
Okay. Now, the officer made it clear that the reason he was looking for Mr. Foley is because Mr. Foley had some outstanding warrants to get him come to court when he was supposed to, correct?
Correct.
All right. And you didn't help the officer in locating Mr. Foley. You didn't take him to your house and say, here's where he is, right?
No, he wasn't at my house at that point.
At that point, he wasn't, but he prior had.
Yes.
Okay. All right. And did the officer tell you that he was looking for a count of a felony or misdemeanor?
Yes.
Okay. All right.
Are you satisfied with that factual basis?
I'm satisfied.
Ms. Goodrich?
Yes.
Okay, Ms. Fidel, on April 14th, were you in Sheboygan County?
Yes. Sir.
And you had some contact with law enforcement?
Yes.
And were you in possession of the controlled substance methamphetamine?
Yes. Sir.
Did you know that you were in possession of that substance?
Yes.
Did you have any lawful authority to possess that substance?
No.
Are you satisfied, Mr. Clan? Ms. Goodrich?
Yes.
Mr. Clan, are you aware of any other promises, threats, or inducements?
No.
Do you believe I've complied with the courtroom? Ms. Goodrich, do you agree on both matters?
Yes.
All right, Ms. Bedell, I find that your plea is knowingly, understandingly, and voluntarily made. And then that there's a sufficient basis in fact and law to believe you're guilty of those offenses. So I hereby accept your plea in both files. We'll schedule it for sentencing on October 7th at 1 p.m. And you'll have to cooperate with an interview, so a pre-sentence report could be prepared. The parties have any input about what we ought to do in terms of any bond between now and then?
Your Honor, I would not object to do what we did on the earlier case where her bond is reinstated and we see how she performs on bond between now and sentencing.
Mr. Clan?
I'm in agreement with that. I just want to make a little bit of a record. Brandy, you and I discussed some issues that you had with your urine test, correct? And now Judge Gauthier has told you that if you have another dilute urine screen, that'd be a bond violation, right?
Correct.
And what did he just tell you about what would happen if you had another bond violation with regards to the sunscreen?
The clear.
No, the sunscreen would be taken back. You wouldn't have to follow it, correct?
Correct.
Okay. So now you have an added incentive not to have a dilute urine screen, correct?
Correct.
Okay. I'm satisfied now that I made that clarification on that.
All right, well, Ms. Bedell, I'm going to reinstate your bond with the same conditions. Whatever issues were going on, I don't want you to talk about that with me now, and I'm not asking you to admit anything about that, but you want to figure out with Mr. Clayune what were the issues so that they don't happen.
Yes, sir.
If the issues were that you were just not able to stop using, there are other ways we can approach that by getting you into either inpatient or outpatient treatment, and we'd be glad to help with that stuff. So whatever the issues are, talk with Mr. Clayune honestly about those, and I think you'd find that we'd want to help with those things. But he's right. If you violate bond between now and the sentencing date, things will not go well for you.
Yes,
Okay, we'll see you back on, and you have to schedule, as soon as you get released, contact the probation department to schedule an interview. It's your responsibility to make sure that happens, okay?
Thank
All
you.
right, anything further from the people?
Mayor.
Defense?
No.
Okay.
All right.
Next we have. We might get that paperwork done today, but it's possible it may not get done till the morning. We also have a sentencing in People v. Gregory Frisky. It's file 24-6860FH.
Thank you. Brian, could you have Greg Frisky's post counsel to my right? Your Honor, I'm going to ask the court respectfully to adjourn Mr. Frisky's sentencing. Mr. Frisky today has expressed some misunderstanding and frankly displeasure with the work that I've done for him. Without going any further, I think he wants to seek the advice of alternate counsel. I would not be comfortable continuing on with the sentencing in this case based on the conversation we had without going into details.
Okay, well, Mr. Frisky, we are here for sentencing, and you knew it was for sentencing. There's a mandatory minimum jail for this offense. So I can't just start having people show up for their sentencing who don't want to go to jail and say, I'm unhappy with my lawyer, kick it down the road. So I'm happy to adjourn it so that you can explore whatever with Mr. Clayton or another counsel, but I'll be remanding you to jail today nonetheless and canceling your bond. So you can't, like, just by saying I'm unhappy, avoid going to jail today. If that means you need another minute to talk to Mr. Clayton, I'm happy to give that to you. But I'm not going to have defendants just show up for their sentencing and say, I'm unhappy, and walk back out that door. Do you understand that?
Yes, Your Honor.
So whatever happens next, you're going through that door. You understand that?
I was misinformed.
I don't care. Whatever happens next, you're going through that door, and we'll sort it out later. I'm happy to sort it out later, or we can do your sentencing now. Your choice.
You're gonna have to do that from the chair. Yes, Paul? If I were to press you, I don't know.
Wow. Crime does not pay. Believe me.
Mr. Frisky wants to adjourn sentencing to explore.
Okay, that's fine. And I wouldn't want to put you in a position of going forward when you don't feel comfortable with that either. So we'll continue the sentencing to September 9th so that it's less than the mandatory minimum amount. So it won't prejudice Mr. Frisky at all. We'll continue the sentencing to September 9 at 1:20 p.m. And that's a time you're here anyway, Mr. Clayton, because Mr. Clayton is still attorney of record until anything changes about that. And I am going to order Mr. Frisky's bond to be canceled and remanded to the custody of the Sheboygan County Sheriff until further order of the court. And we'll see you next on September 9th at 1:20 in the afternoon.
Am I supposed to go get that breath thing and bring that in, or?
I'm going to the jail right now.
I'm sure I can get it back.
Yeah.
Fine.
I've got Miss, I've got attorney. Is that all you have, Mr. Clayton?
Yeah, I do have that amended on the bill.
Okay.
Mr. Clayton.
Thank you. You can approach.
Oh, no, not in the back about, I acknowledge receipt.
Okay, great. All right, Ms. McGregor, good afternoon.
Good afternoon, Your Honor.
All right, this is People v. Jeffrey Oliver, file 25-6979FH. Is Mr. Oliver still in Chippewa County Jail?
He is, Your Honor.
They have not zoomed in. It was scheduled for 1:40. It's 2:13. I don't see them. So I think Ms. Goodrich is texting away to see if her office can check into that. So my apologies, Ms. McGregor. I'll place you back in a waiting room for a little bit and we'll see if Chippewa, well, I guess, do you have anything that you know we're doing today?
I think we're just going to be pushing back. I spoke with the prosecutor last week, and as the court's aware, there is other charges in 2 other counties. And so we are attempting to work out a global resolution. I think we have made some progress and I'm encouraged. But overall, we still need a little bit more time. I think the prosecutor was okay with that as well. And we'll be pushing back the contempt issue as well.
Okay. You agree with that, Ms. Goodrich?
Yes, no.
Okay, so I'll excuse Mr. Oliver's non-appearance and we'll just continue this. We don't need them to zoom in. We'll just have to make sure that we reiterate to them to get them on next time. And let's continue this out to, would September 30 give you enough time to sort that out, Ms. McGregor?
I am hopeful. I do have a Zoom call of the calendar out of Berg at 1 on the 30th. I just need to avoid that time.
Okay, well, I could do that, or if you think based on the other charges in the other counties, a little more time is necessary, I could put it to October 7.
I would like a little more time, yes, if the court's okay with that.
Sure, let's do October 7 at 1:40 p.m. Allow Zoom appearances for that.
It does look like Your Honor is set for trial in Chippewa County, October 15th.
Oh, he's set for trial in Chippewa County, October 15th. Do you want me to put this beyond that?
So I'm not sure if Ms. McGregor wants a later date due to that.
Do we want to push it out to October 21 then?
Yes, that's a good idea.
Okay.
Thank you for that. I wasn't aware that was
Okay.
set.
So let's do October 21 at 1:40
That will work.
for a docket call and also a status conference on the pending contempt. Okay, anything further from the people?
Your Honor, thank you.
From the defense?
Just one thing really quickly. I was scoring Mr. Oliver today, and I'm wondering what the prosecutor's position is on the consecutive sentencing, because that's not in the, at least that's not in the offer that we had discussed at all last week. So I'm wondering what your position is on consecutive sentencing.
I can contact you on that.
Okay, that sounds good. Okay, nothing further, Your Honor.
Okay, if it helps, Ms. McGregor, and I don't know all the circumstances, but I've interpreted the statute about crimes committed in a penal institution to apply to pretrial detention. I am aware of an unpublished Court of Appeals decision interpreting the statute otherwise. I think the panel was wrong and it's not binding, but the statute is binding. So until there's a published opinion, I'm going to follow what I think the statute says on that. I don't know if that's what applies to Mr. Oliver, but I want to let you know that's my thoughts on it.
Well, I appreciate that, because that is in addition to what I was referencing, which is count 3, tampering with evidence. And that's a discretionary per statute.
Okay. Okay, very good. You have a good day.
Thank you.
All right, and that'll bring us next to People v. Richard Deach, file 25-7014, FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
And good afternoon, Your Honor. James Gilbert here on behalf of Mr. Deach.
All right, and we're here for a docket call. Do you know how we're proceeding today?
Well, Your Honor, my understanding was we're currently, and I know I've been to the last couple of meetings, that Mr. Deach is waiting
Yes.
Do you consent to that, Mr. Gilbert?
I do, Your Honor.
Okay, Mr. Deitch, would you please stand and as best you can, raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, go ahead and be seated. Mr. Deitch, guilty plea hearing is an important event. It includes the waiver of constitutional rights you have, so listen carefully. If you have a question, ask me. If you need time to talk to Mr. Gilbert, you just say so, okay?
Yes, sir.
I have to advise you the maximum penalty you could face. Count 1 is possession of methamphetamine with a habitual second that's punishable by up to 15 years in prison and or a $15,000 fine. Count 2, tampering with evidence with the habitual second is a felony punishable by 6 years and a $10,000 fine. Or that's conspiracy to tamper with evidence. Count 3, tampering with evidence is with the habitual second, felony punishable by 6 years and or $5,000 fine and consecutive sentence discretionary. Count 4, possession of clonazepam with the habitual second is a felony punishable by 3 years and or $2,000 fine. Count 4, maintaining a drug house with habitual second is a felony punishable by 3 years and or $25,000 fine. All that together means the maximum exposure you would have would be 15 years for the possession of methamphetamine plus 6 years discretionary consecutive for tampering with evidence. For the total possible under the law you could receive on this case would be 21 years in prison. Do you understand that, sir?
Yes, sir.
Are you on probation or parole?
No, sir.
Were you on bond for any other cases at the time of the incident?
No, sir.
Do you understand if you plead guilty, you won't have a trial and you give up the rights you would have had?
Yes, sir.
Those rights include the right to be tried by a jury and at that trial to be presumed innocent, unless and until the prosecutor proves your guilt beyond a reasonable doubt. The right to have the witnesses against you appear and to question them. The right to present witnesses in your own defense and have me order those folks to show up. Do you understand those rights?
Yes, sir.
Do you wish to give those rights up and enter a plea here today?
Yes, sir.
If I accept your plea, you give up any claim that it was caused by threats or any promises beyond the plea agreement. Do you understand that?
Yes, sir.
Also, when you plead guilty, you lose the right to appeal. And if you want to appeal, you have to seek permission, file an application for it. The types of issues you could raise after pleading guilty are very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes, sir.
All right, the plea agreement is in exchange for your plea to the charges I outlined. The prosecutor will dismiss the drug doubles. And also there's a sentence agreement for you to be placed in our recovery program. Do you understand that?
Yes, sir.
Now, I don't have to follow that sentence agreement. We talked as a team and thought that was you fit the requirements of that program. The final decision would be mine at sentencing. If I don't continue you in the program, you'd be allowed to withdraw the plea, not having received what you bargained for. Do you understand that?
Yes, sir.
There's a very important exception to that. If you get yourself in trouble between now and the sentencing by skipping court, absconding your bond, committing a new crime, or violating your bond, any of that type of behavior, you would, by your own misconduct, lose the right to withdraw the plea, even if I don't follow the agreement. Understand that?
Yes, sir.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, sir.
Has anybody threatened you to make you?
No, sir.
Is it your own free choice to enter that plea?
Yes, Your Honor.
Knowing all this, how do you wish to plead to possession of methamphetamine?
Guilty.
Conspiracy to tamper with evidence?
Guilty.
Tampering with evidence?
Guilty.
Possession of clonazepam?
Guilty.
Maintaining a drug house?
Guilty.
And habitual offender second?
Guilty.
So, Mr. Deitch, back in February of this year, were you in Sheboygan County?
Yes, sir.
Did you have some conversations with the James Van Alstyne about helping him hide or tamper with evidence against him?
Yes, Your Honor.
And did you and he reach an agreement about tampering or hiding that evidence?
Yes, Your Honor.
And did you in fact take that evidence and conceal or tamper with it?
Yes, sir.
Did that occur in Sheboygan County?
Yes, sir.
Did you later have some contact with the police?
Yes, sir.
Did they find that you were in possession of the controlled substance methamphetamine
Yes, sir.
and the controlled substance clonazepam?
Yes, sir.
Did you know that you were in possession of those substances?
No, sir.
Okay, did you know that you were in possession of something?
Yes, sir.
You just didn't know exactly what it was?
Right, sir.
And it tested positive later for methamphetamine and clonazepam.
Yes, sir.
You don't have any reason to doubt those test results?
No, sir.
And for the maintaining, were these substances kept at your residence?
I was living with my mother at the time and they were kept at the residence of my mother.
Okay, and you were the one that placed and kept them there?
Yes, sir.
All right, and did you have a previous conviction for maintaining a drug house in 2019 in this court?
Yes, sir.
And Mr. Gilbert, you satisfied with that factual basis?
I am, thank you.
Ms. Goodrich?
Yes.
Mr. Gilbert, you aware of any other promises to inducements?
I am not.
Ms. Goodrich?
No, Your Honor.
Mr. Gilbert, you believe I complied with MCR 6.302?
I believe you have, thank you.
Ms. Goodrich?
Yes.
Mr. Deitch, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of those offenses, so I'll accept your plea. We'll schedule sentencing for October 7th at 2:20. And Ms. Goodrich, do you want me to amend bond conditions to participate in recovery court?
Yes, Your Honor.
Any objection to him starting that now, Mr. Gilbert?
No, Your Honor.
Okay, so Mr. Deitch, I know we had canceled your bond. I'm going to amend it and have a $5,000 personal recognizance bond, so you don't have to post any money for release. And it'll have recovery court conditions. So immediately upon your release, I want you to see Nicole. If that happens today, if it doesn't happen this afternoon and you get out in the morning, we'll see you in the morning. But whether you get out tonight, if you get out tonight, you have to be in court tomorrow for recovery court. We meet every Wednesday and the men have to report at 9:30 in the morning here in the courtroom. Okay?
And this one?
Yes.
Yes, sir.
So if we get the paperwork done and you get out tonight, we'll see you at 9:30 in the morning here in the courtroom.
Okay.
Sometimes we still have a busy afternoon. It's possible I don't get that signed today and you'll still do one more overnight and we'll bring you out in the morning and get the paperwork done then, okay?
Okay.
We'll
Yes,
do
sir.
what we can to get it out tonight, but sometimes that doesn't happen.
Yes, sir.
All right, anything further from the people,
No, Your Honor.
from the
No, Your
defense? Okay, we'll see you then, Mr. Beach.
Thank you, Your Honor.
All right, do we have Mr. Schmidt? Okay, we're gonna call that, Mr. Kylenda traveled up for that, and we'll get him on the road. All right, so this is People v. Jerry Schmidt, file 24-6824FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
And good afternoon, Your Honor. For the record, Paul Talenda on behalf of Mr. Schmidt, present tomorrow. Date and time set for sentencing this matter.
All right, and I have had a chance to review your sentencing memoranda that you submitted. Thank you very much.
Thank you, Your Honor.
Have you had a chance to review the pre-sentence report and recommendations with your client?
I have, Your Honor.
Any additions or corrections or modifications from the defense?
Your Honor, just the ones that I'm going to discuss that reference my, in my sentencing memorandum. We find it factually accurate. The information is, I believe, complete. There's nothing to note of deletions or errors and the like. I would just.
Did you have some scoring challenges you want?
I do, Your Honor. I have some allocution.
Okay, Ms. Goodrich, any additions or corrections to the factual information?
No, Your Honor.
I do think we need to change credit. The credit was calculated through to July 22nd, and it's August 26th today for some continuances. So I haven't done the math.
35 days.
35.
And so it should be 477 plus 35.
512.
That's what I got. But I'm not saying it's right.
Okay. All right. So go ahead with the scoring challenge. You had PRV 7.
Your Honor, yes. In my first challenge comes in the discrepancy is the court would notice that when my client was pled to, I believe, 7 offenses on a habitual fourth, the scoring somehow came out at 5 to 23, and then 5 to 46. And then when he was scored on pleading to 2 offenses with no habitual, it came out to 34 to 67. That was the first start. I go back and I look at the PRV scores, and I look back to in the 10 years preceding the nature of this offense, there's a possession of marijuana from a different state. That offense translated to the state of Michigan does not equate to a criminal offense. It's the same way as in the Carolinas, they have, I believe it's called felonious speeding. But if you are convicted of that down there, it comes back to a civil infraction. So in the like, he has no cognizable offenses in the criminal law in the state of Michigan or elsewhere. Well, I should say to be acknowledged elsewhere. And it looks like the last conviction would be from 2007 for an indecent exposure in North Dakota. With that in mind, the 10-year gap, the 10-year rule applies in terms of the consideration for the previous offenses in the scoring. With that, my scoring is that all of the prior offenses do fall outside of the 10-year gap and therefore would not be calculated certainly to the higher level. The other side has it is that the PRV score of 10 for concurrent felony convictions, I believe, accounts for the.
Well, hang on, I'd like to do these one at a time. So you've said that you believe all of the prior convictions are barred by the 10-year gap rule?
That's my position, because if the court looks at it, there's nothing that if we go back, we're talking 2023, so we go back to 2013.
But he's got the 2016 and 2018 possessions of marijuana.
Those aren't criminal offenses in Michigan. If those, and I would equate this to the court, is that if those were Michigan convictions, they would have been automatically expunged by the state because they are no longer convictions to be entered on someone's record. Well, again, they would be convictions from other state. We're considering the way that they translate into the view of the Michigan Department of Corrections.
So, but the recreational marijuana was not legal in 2016, is it correct?
That is correct, but what I'm saying to the court is that had these cases been Michigan convictions rather than North Dakota convictions, the operation of Michigan law vacates them because it is no longer an offense inside the state of Michigan. The state of Michigan has no power to vacate an offense that is still a criminal conviction in another state. However, when it translates here for our consideration into criminal purposes, it's not a criminal offense under our jurisprudence.
Well, but for scoring purposes, the prior record variables, the statute counsels that convictions that are set aside or expunged are still counted as prior record variable convictions. So based upon the fact that in 2016, possession of marijuana was still a crime in Michigan, and even if it had been a Michigan crime and expunged, that would still score. I would overrule the 10-year gap objection and still leave the prior convictions fully scoreable. Okay, so that takes care of your 10-year gap objection, and you had a PRV 7 objection. Go ahead with that.
As the PRV, I think other than the court only allows for me to score 10, I mean, in terms of my scoring, I would have all the others set aside and then only have this exist at a level of 10. However, if the court's going to overrule the 10-year gap, then I would make my position that it is properly scored at 0.
Well, I think that the PRV 7 is for concurrent or subsequent convictions. So I understood that to be scored at 20 points because in this case, on scoring the possession of methamphetamine, the sentencing offense, there are 2 other contemporaneous or concurrent or subsequent convictions, the R&O in this case, and the case down in Macomb County. So based on that, Ms. Goodrich, is that your understanding on PRV 7? Yes. Based on that, I would think the PRV 7 is properly scored at 20 points.
The concurrent convictions are, I believe those would fall out because those are subsequent beyond the court, and I believe those.
Hold on while I answer the damn phone. Yeah, they always want me to switch my medical insurance, and I'm not switching. I'm happy with Cigna. Now it's switching back to HealthSpring, but still, I'm happy with my insurance. These people don't stop. And they're rude.
May have been addressed in the contempt here.
PRV 7 is for concurrent or subsequent convictions, so I'm scoring. So what's your next objection?
Okay, then it would be properly scored.
I don't want to hear the objection I just overruled. I want to hear your next objection.
Okay, so the OV12, just if I may, Your Honor.
Sure.
Okay, so OV12.
OV12 was scored at 25 points for 3 or more contemporaneous felonious acts involving crimes against a person.
Okay.
However, the scoring offense, possession of methamphetamine, is not a crime against a person.
Correct.
So we couldn't score the 25 points. Is that your objection?
That's my position. I believe it should be properly scored at 10.
At 10. I think that is correct. Ms. Goodrich, you have any other position with regard to that?
I would agree, Your Honor.
Okay, because the scoring offense of possession of methamphetamine is not a crime against a person, it can't be part of a pattern of crimes against a person. So under OV12, 10 points could be scored because there are 3 or more contemporaneous felonious criminal acts involving other crimes. So OV12 will change from 25 points to 10 points. That would reduce the OBs from 40 points to, goodness, now my math, 25. That means on the D grid, that would be, goes from OB level 4 to OB level 3, which is, instead of 34 to 67, we're at 29 to 57. Is that right?
I would concur with that.
Sorry, so we're still on the D grid, Your Honor?
We're in the D grid for possession of methamphetamine. We're in the F column for OBs, or for PRVs, and we're on OVs at 25 points. I've got at 3 rather than 4. Changing the guidelines from the scored at 34 to 67 to now at 29 to 57.
That looks correct. I also want to challenge OV19, Your Honor.
Okay, go ahead.
There was no threat to security of the penal institution in this matter. There's no convictions on that matter. The other one, as pertains to what was charged under the statute, Mr. Schmidt was not technically a prisoner during the intake. So he was not a prisoner possession contraband because of the intake process. The intake process was not complete. So he was still a custodial arrest, which is a very common position to say, okay, I pick you up, I arrest you during the search of your person for admittance and for the corporal admittance into the DOC or into the jail. At that point, and even as a function of a sentence and a designation, that's what makes someone a prisoner ultimately eligible for a charge to possess something while in another place. However, in a situation such as this case, Your Honor, the possession of methamphetamine was, let's call it, already complete. And so the fact that the discovery of the possession or a subsequent possession or another amount occurred in another location does not change Mr. Schmidt's category from detainee or in custody under investigation to the status of prisoner. And so with that, there's no threat to it because he was not interfering with anything having to do with and it's scored currently at 15, which indicates that there was either a used force or threat of another used force or the threat of force against another person or the property of another person to interfere with, attempt to interfere with, or that results with the administration of justice or the rendering of emergency services. So just having meth doesn't actually interfere with anything. It causes no waves in the smooth sailing of the administration of justice.
I think there's some recent cases from the Michigan Supreme Court that I think may bolster your position with regard to the mere possession of a substance during the booking process. But I wonder if you have a position about 15 points can also be scored for use of force or a threat of force against another person to attempt to interfere with the administration of justice, which the case law does say applies to responding officers. And he also has the conviction for the R&O, and that in the description of the offense does include some threats to the officer, as well as it was a physical R&O, but also, for example, he told the trooper that if he got touched, they would be fighting. Is that not properly scoreable for 15 points for a threat of force?
It's not, because I believe it certainly is consumed by the other offense that he's been convicted of. It is, let's call it a part of the R&O. It is within the full function of the offense of R&O. And the words don't mean much, right? I think that the fact of there were 4 or 5 officers, much larger, much outnumbered than Mr. Schmidt. I don't think that there were facts in play that made, let's just say, any statement coming from Mr. Schmidt a reasonable threat. I think that by the time the police officers figured out that Mr. Schmidt had called the cops on himself from his paranoia, that his behavior once immediately out of the vehicle was the bulk of the behavior. So there's nothing beyond that, so that the behavior that the court's referring to is actually consumed by the R&O as part of the R&O, and thereafter there was no danger or threat or any facts that support that it was perceivable or anything meant to interfere with the administration of justice, rather than just what's part and parcel to corralling a new arrestee.
Okay, thank you. Ms. Goodrich, what's your position on OB 19?
Your Honor, I would disagree. The defendant is first walking from his car towards the officers, yelling at them. He then is turning back towards his vehicle. I think that the officer is certainly going to treat somebody different who says that if they get touched, they're going to be fighting, versus somebody not saying that. I think that it was a volatile situation at that point with the statements that the defendant was making and his behavior and decisions he was making towards the officers.
Okay, I'm going to assume, without deciding, that the scoring would not, that the possession of the drugs during the booking process would not be the basis for the scoring. But I do think it is properly scored at 15 points for a use of force or threat of force against the law enforcement officers in an attempt to interfere with the administration of justice. The fact that he was, you're going to again argue an objection you already made. That's not how I do business.
I'm sorry,
I'm making my ruling, so please let me make my ruling. Please let me make my ruling so that my thought process is not interrupted. I do not do business. I let both sides speak their piece, then I speak mine. It is properly scored at 15 points for the use of force or threat of force against another person, the law enforcement officers, in an attempt to interfere with the administration of justice. The fact that he was convicted separately of the R&O does not prevent the basis of those facts being used to score offense variables. That happens all the time. There's no double jeopardy for scoring offense variables based upon conduct that another conviction was based upon. So the objection to OB 19 is overruled.
Thank you.
The guidelines as I have it scored is 2957.
If I may, I have an objection just for the record, Your Honor.
Sure.
Part of the paragraph that the court was referring to that has to do with touch me and we're fighting, for the sake of completeness, if the court goes down a line and a half, Also, the next thing said, or the follow-up is that Mr. Schmidt, quote, "I need to shut my fucking mouth and listen."
You overestimate my interest in objections I've already ruled on. Do you have another objection?
I'm making a record, I think.
Okay. Ms. Goodrich, any objections from the people this room?
No, Your Honor.
All right, now the guidelines are scored at 29 to 57 months. Any allocution you want to make, go ahead.
I do, Your Honor, thank you. I can appreciate that drug offenses are unfortunately common. However, the tendency in our state and with our jurisprudence is to properly treat mental health issues as mental health issues. In a situation like this, the court has seen and has enough evidence in front of it to indicate that this is a mental health issue. It's reflective of the road that is affected by the people who seek out self-medication because they have other instances going on, and they might not be able to either have the proper foundations, the proper medical treatment, or the proper care to address truly how they got into drugs. As we've seen from Mr. Schmidt's behavior from this offense, as I've said, this is simply the product of a previously diagnosed mental health issue and the use of drugs. That collision led to this behavior. This isn't a malicious and terrible act. This isn't a vicious act. This isn't an act where Mr. Schmidt is out seeking to cause harm. Now, it's appreciable that this type of behavior does cause harm, accidents, other type of people having to deal with the erratic behavior of these types of situations. However, they are brief. They are not a continuing pattern of criminal behavior. It's not something with which the court has to be afraid of. It's more the court has to be concerned about the path for the individual. And as we've seen from Mr. Schmidt, he has 25 years of minor offenses, other than these two offenses that brought him to court and the two offenses that now he's currently on probation for and the one he faces sentence for. There was the efforts to get Mr. Schmidt into treatment because treatment was what was thought to be best for him. These treatment programs exist to provide alternatives to the straight punishment of jail and to provide for the rehabilitation process that is certainly the most important part of the criminal sentencing aspect. We can appreciate that the court doesn't penalize and doesn't punish people out of enjoyment, and it doesn't punish people out of lack of other opportunities and options that exist for defendants in these situations. The court does it because the court will use every tool in the toolbox, and I ask the court to use the smaller hammers up front. Mr. Schmidt has 512 days. My scoring guidelines had him at 0 to 17 months. 510 days is about 17 months. So in understanding that Mr. Schmidt has served the maximum of my assessment, and of course it differs from what the court has assessed, that amount of jail time has provided a punitive measure, a corporal punishment measure. It has provided this court the jail end of the portion of the punishment that Mr. Schmidt had to face based on what he did and how he got here. Now that he's faced that part of it, and now that he's done, let's call it the hard part, I'd ask the court to allow him to do the hardest part, where he has been invited to do so. Macomb County has put him on probation. They've provided for him to be through, to have programming once he's out of the Sheboygan County system. I ask the court to put him down there because I believe that aside from the, let's say, the unfortunate ineligibility of having two cases that may have kept him out of the treatment court in both counties, I don't believe that let's say the policy that kept him out has anything to do with the fact that Mr. Schmidt is still willing and able to engage in the type of treatment that would keep him from repeating this. And I believe that the program in Macomb County, while not the truly four-corner, very hard, difficult treatment court, their treatment plans are very similar. He would go through the same thing. I believe that the stability that is provided through the home life and through the opportunities that exist from Mr. Schmidt to return back to his employment and to the rigors of that probation, will provide him the opportunity. And I think this court can take comfort in the fact that while there may be concern for the general safety, certainly within the community and certainly within the state, that Mr. Schmidt has been punished sufficiently, and we're going to allow him, we'd ask the court to allow him to make his way out of the hole that he's dug. And at those places, let's call it the ladder, that rope that he can certainly climb out with, or certainly turn around and hang himself with, exists back home. And what I asked the court to do is allow him to try to succeed there, because the court knows that if that success is not where it should be, the Macomb County they'll put him in DOC. There'll be no second chances. And if the court would like to retain Mr. Schmidt on probation for those purposes, accounting for the fact that he is currently indigent and, let's say, wouldn't be able to come here to the court, but the transfer to Macomb County would certainly satisfy both sides. It would certainly be a further carrot and a stick to allow Mr. Schmidt to prove himself and to recover himself for the rest, because again, then you would have two judges that could hold different sentences above him for similar or different violations. And if there's nothing more motivating than fear, the belief in self to succeed, which Mr. Schmidt has, and the self-confidence that it takes to acknowledge your triggers and to step beyond them and to stay away, as we've seen that he's been able to do in large periods of time over the last 25 years. And so I'd ask the court that we acknowledge that we've gotten our pound of flesh and that we let Mr. Schmidt prove himself to get through the mental health hurdles that brought him here. Because we know that if Mr. Schmidt can't adhere to the strict guidelines of what it takes to have clean mental health on the outside, well, then we know that he can go and have his mental health episodes locked up somewhere else. But I believe that we should give him that chance.
Thank you, Mr. Cullen. Mr. Schmidt, it's not required you would make a statement today, but you are certainly allowed to. Is there anything you want to tell me, sir, or no?
No, sir, not at this time.
So reaching recommendations from people.
Yeah, sure. Thank you. The defendant is 52 years old. He has 7 prior felonies and 5 misdemeanors. His first crime was back in 1988, and we continue it since then. He served 4 years in prison, it looks like in 1993. He had a case in 2007, which he currently is not in compliance with. He stopped reporting in September of 2023, according to the PSI. And then in 2009, he spent 5 years in prison and now here before us today with a recent case in another county as well. I would ask the court to follow the recommendations.
Thank you. Well, Mr. Schmidt, we have to come up with a sentence that's proportionate to the circumstances of the offense and the offender. So the punishment has got to fit the crime, but it also has to fit the criminal. So as I would expect, given this circumstance, your attorney has focused on the circumstances of the crime, which, although serious and dangerous, does have certainly some real mitigating factors to it, and would not be the kind of thing that would get a circuit judge all wound up about. And the prosecutor, by contrast, is going to emphasize your criminal history, which kind of does. So, you've got a prior record that I do find troubling. You've got a little bit of everything. You've got some thefts, some assaults, including aggravated assaults, a sexual crime, a weapons crime. And then in North Dakota, I don't know what their laws are like or what this was, but something called a felonious restraint and something called a terrorizing. I don't know if that's just fancy words for some domestic assault. I don't know. But so you've got several prior felonies. You've been to prison before. You fail to appear in this case. And then while you're on absconder status and warrant status for several months, you commit a new felony down in Macomb County. That's all very troubling. And the prosecutor is, I guess opted not to charge you with absconding in this case. That's fine. But that happened. And so all of that would mean that, if I just look at that, so if I look at just the crime alone, I would probably go toward lower end of the guidelines, whatever they are. If I look at your history, I'd go toward the upper end of the guidelines. So balancing that out, I think that a sentence within those guidelines is proportionate. I'm not going to follow your attorney's recommendation to essentially downwardly depart from what those guidelines are. So I think taking all those things into account, I'm going to assess crime victims assessment of $130, their state cost of $136, and court costs of $350. On the R&O, I'll order you serve 512 days jail with credit for 512 days credit. And on the principal charge, the possession methamphetamine with the guidelines of 29 to 57 months, I'm going to commit you to the Michigan Department of Corrections for not less than 36 months to not more than 10 years with credit for 512 days previously served. And that's within the advisory guidelines. I think it is proportionate to the circumstances of the offense and the offender, and reduced my sentence from what was recommended by the DOC, partly because of the reduction in the guideline score as well. And so that's the sentence of the court. If you want to appeal from that, you can file an application. If you want a lawyer appointed for you and qualify, you have to make that request within 6 months. We're going to hand you a piece of paper explaining those appeal rights to you, Mr. Schmidt, and ask you to initial one copy for us, and the other one is for you to fill out if you wish to take an appeal. Oh, also, the R&O is discretionary consecutive. I'll run that concurrent, so you get the credit on both. All right, so anything further from the people?
No, Your Honor, thank you.
Defense?
Oh, yeah, thank you.
Okay, thank you, Mr. Thailenda.
Thank you.
I think I do see the Otsego County Jail zooming in, so I think I want to call Mr. LaFave next so that we can accommodate the Otsego County Jail there. All right, Mr. LaFave, can you hear us, sir?
Yes, sir.
All right, this is People v. Michael LaFave, file 24-6895FH and 25-6992FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
Good afternoon, may it please the Honorable Court, Kareem Johnson from the office of LaFave.
All right, so Mr. LaFave is appearing from the Otsego County Jail where he's serving a sentence. We're here for a docket call on both these matters after we've had some motion practice in this case. And Mr. Johnson, what's our status in both these matters?
Yeah, I did approach Ms. Goodrich today with a potential resolution. I think it resolved all, outstanding issues. I'd ask the court for a brief adjournment of this matter.
Okay.
Also,
would you be available if we put it 2 weeks out to September 9th in the morning if it was a Zoom appearance?
yes, Your Honor, I would.
Okay. Would that be a date that would be fine, Ms. Goodrich?
Yes.
All right, so on both these matters, let's continue the docket call to September 9th at 9:50 a.m. and allow Zoom appearances from Otsego County Jail for Mr. LaFave, and Mr. Johnson can Zoom in from wherever he'd like to.
Thank you.
And then if it's not resolved, then we can look at trial dates and which ones we're going to try first or in what order or anything like that. All right, anything further from the people on that file?
No, Your Honor.
From the defense?
No, Your Honor.
Okay, thank you, Mr. LaFave. You have a good day.
Thank you.
Mr. Gilbert, how about Mr. Tom Errolson? This is file 24-6957 FH. Here for a docket call, we have a jury trial scheduled for September 11 and 12.
That is correct, Your
Is
Honor.
that still our plan?
That is still our plan.
Okay. Any need for further docket call, or we're all set?
I don't believe so. I think we're all set.
Okay. And I'll have jury instructions and verdict forms not later than 7 days prior. Witnesses have been exchanged, I take it then?
I believe so.
Okay. All right, Mr. Errolson, we will see you for your jury trial on Thursday, September 11th, going into the 12th as needed. Okay, thank you. And People v. Nicole Fisher, 24-6929. That is scheduled for jury trial, I think, is that next week?
It is next week.
Okay. And is that still our plan?
It is tentatively, Your Honor. I have been working with the prosecutor about interviewing the alleged victim in this matter. I would just like to, we're still trying to work on a resolution possibly.
Okay. I won't schedule anything further. You can just let the assignment clerk know if anything changes then. I mean, we've already got summons out and stuff, and so, but let us know if anything changes. We can get something scheduled if there's a pre-trial issue or a resolution.
Excellent. Thank you.
Take care.
Okay, we'll see you next week then. That bring us to People v. Brent Frank, file 25-7044. This is up for a docket call. What's our status in this one?
Your Honor, this matter has not been resolved. I guess whatever pleases the court, I guess we could go on the trial docket or give us a little bit more time to see if there's a resolution. At this point, we're not close.
Okay. Well, I can add it to the trial docket, but then not give a firm date today, and we'll come back and then grab a date.
That would be perfect.
So let's do this. We'll add you, Mr. Frank, to our trial docket. And he's been in custody since when?
May 28th.
February 28th? May 20th.
Yes, some district court matters pending as well.
Oh, district court matters are pending. And the bind over was on June 12. What'd be the estimated length of trial?
Monday.
Oh, Monday? Okay, Monday.
Do you know when the next dates are in district court, or what's happening next in the district court matters, or?
Well, we did have something scheduled for this week, Your Honor. However, the trial that we have Thursday and Friday got it adjourned. So I think it got bumped out till the 3rd. I think a lot of things were being moved to the 3rd.
Okay. Well, let's, I've got it on the trial docket. It's a fairly recent case, but he is in custody. But let's come back for a docket call on September 30 at 2:20. And I'll make a note to myself that on that date, if the defense wants, I'll give you a firm trial date.
Your Honor, is there a possibility September 30th? There is a very high possibility I might be in Houston, Texas.
Oh, okay. Yeah, we can bump that to October 7.
Perfect, thank you.
7 at 2:30. And I'll give each side 21 days from today to file witness and exhibit lists. Okay, so Mr. Frank, we'll see you on October 7th, and at that date, get you a trial date if necessary, okay? Okay. Brings us next to Ms. Johnson. Marissa Johnson is zooming in. All right, this is People v. Marissa Johnson. It's filed 25-7033 for docket call and 24-6812 for a status conference on the on a pending probation violation. It says contempt, but it's probation violation. Mr. Gilbert, what's our status?
Your Honor, the prosecutor has forwarded over a possible plea agreement. However, in talking with my client, we would like to set that that hearing for an actual evidentiary hearing on that probation violation.
Okay. Let's do this then. And just a continuing docket call on the Johnson, or on the new file then?
If we could, Your Honor, because I believe the results of that hearing would probably control contempt plea.
Okay. Well, oh no, mornings are not, you can't do mornings, I'm sorry. And how much time would you anticipate you need, Ms. Goodrich, for a evidentiary hearing?
Probably just a half hour.
Okay. Let's schedule this for October 7 at 3:30 in the afternoon. For a docket call in 7033 and for an evidentiary hearing on a probation violation in the 6812. And so, Ms. Johnson, we'll have to have you here in person for those hearings, okay? She's muted, but I did see her.
Okay.
Okay. All right, we'll see you October 7 at 3:30 in the afternoon, okay?
Great, thank you.
And then let's do Elmer Truman's next. All right, and up next we have sentencing in People v. Elmer Truman. It's two files, 25-6978FC. 25 advised me that the minor.
Well, that's it for today. I think that one was a repeat that we did with Judge Gauthier before. I want to thank all the subscribers to this channel. Thank you very much for your support. And welcome to all the new subscribers to this channel. Welcome and thank you for your support. If you're not a subscriber to this channel and you enjoy the content that's on this channel, please consider subscribing to this channel. By doing so, you are helping this channel grow and you're helping this platform grow. And don't forget to hit all notifications. That lets you know when I go live or when a new video is uploaded. So that's it for today. Ciao, ciao, ta-ta. Have a good evening. Tomorrow is Saturday, which is miscellaneous case stuff. And then Sunday is our landlord-tenant case. And I will see you then. You will have a wonderful evening. Thank you for watching. I'll see you again soon.
You know how to man all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Fix it, Daniel. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, fixing your hour, standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's okay. Daniel, you're the one who saves